Good morning, everyone, and welcome to our HRLaw webinar. I think this might be a first, a webinar on the 29th of February. So I'm Jo Chatterton. I'm head of the Employment and Immigration team here at Fox Williams. Before we start, just a few administrative points. The webinar is going to be recorded and it will be made available to those who've registered but have not been able to join us this morning. We're very happy to take questions on the topics under discussion. Could I ask you please to put any questions into the Q&A box rather than the chat box, and we'll aim to cover these if we've got time at the end of the session with a view to finishing promptly at 10 o'clock. So in today's webinar, we're going to be discussing data subject access requests, or DSARs, or SARs as they're widely known. And these are notorious for being the thorn in the side of employers because of the amount of management time they can take up, and of course all the admin that goes with them. Now, these have really become, I think, increasingly the first line of attack for any employee who has a grievance or is unhappy about the termination of their employment, and as a precursor to potential litigation. And I think that my colleagues Lucy and Sajina, I know, are far too young to remember when this act was first, when DSARs were first introduced in 1998. But I am old enough to recall that and remember advising on them at the time. And the main area of concern appeared to be whether your paper files in filing cabinets or in paper folders relating to your employees constituted relevant filing systems which would have to be searched for data and for that data to be disclosed. Now, since then, the world has moved on significantly, obviously. So now, really, the sort of majority of employee and workforce communications seems to take place in written form, on emails, and in various different chat functions that we all use at work, including on phones, WhatsApp messages, etc. So the amount of data that comes back for these searches has sort of exponentially increased, and that has led to, as I've said, a huge amount of work and a lot of hassle for everybody. So it's obviously really important that we all try to understand what our obligations are and what we can do to help manage these processes in an effective and efficient way. So my colleague Gina is going to kick off this morning by reminding us of the ins and outs of the DSAR regime and your obligations as employers in relation to employee data. And Lucy is then going to discuss tactical moves that you as employers can consider to better manage the process of responding to DSARs. And we're also going to offer some tips for dealing with 3 particularly tricky DSAR requests. So without any further ado, I will hand over to Sajina to start the session. Thank you.
Thank you for the introduction, Jo, and thank you to everyone who's joined us this morning for this webinar, especially as I appreciate it's not the lightest topic to cover at 9 o'clock in the morning. Next slide, please. I'll start off with why DSARs can be extremely problematic for employers. This is illustrated by the fact that between April 2022 and March 2023, the Information Commissioner's Office received over 15,000 complaints related to DSARs. Many employers misunderstand the nature of DSARs or underestimate the importance of responding to them. Even where they're used to dealing with DSARs, employers can sometimes fail to appreciate that each DSAR is different and needs to be dealt with on a case-by-case basis. Some of the problems that we've identified when advising clients on DSARs include confusion about what actually constitutes a DSAR. The GDPR does not set out any formal requirements for the format of a request, so it's not always the case that the request will contain the words data subject access request. An employee might simply ask, what information do you have on my file? Or can I have the emails that my manager sent about my bonus award? The informal nature of these requests can cause confusion amongst employers, especially if it's said to someone who's not used to dealing with DSARs. Another problem that employers encounter is failing to comply with the time limit due to a lack of knowledge. DSARs can also be extremely time-consuming and therefore a huge administrative burden on employers. Where things don't go right, employers risk a complaint being made to the Information Commissioner. DSARs can also reveal a smoking gun, which can prompt someone to put in their claim form with ACAS, For example, if an employee believes that they've been discriminated against because of their pregnancy, coming across an email from their line manager saying something along the lines of X's performance will clearly drop off a cliff because of her condition could clearly fuel a discrimination claim. Next slide, please. The current data protection regime is set out in UK GDPR and the Data Protection Act 2018. They need to be considered together because the former contains the rights that data subjects can exercise, and the latter sets out the exemptions that apply to those rights. It's also worth noting that the EU GDPR has extraterritorial effect, which means that it might also apply to UK data controllers who have an establishment in the EU or who offer goods or services to data subjects in the EU. So dual regulatory regimes may apply to some of you. The ICO has recognized the need to provide additional support to data controllers, and in 2023, it published new guidance on how to respond effectively to DSARs. It's a good first port of call if you're unsure of how to deal with an aspect of the regime. At present, the Data Protection and Digital Information Bill is also making its way through Parliament. The bill aims to tread carefully between the UK creating its own data laws post-Brexit, but also not going so far as to cause any sticking points with the EU when compared with GDPR. Next slide, please. So it might seem obvious, but sometimes we find that clients struggle to fully understand what amounts to personal data. The starting point is Article 4 of UK GDPR, which states that personal data is any information relating to an identified or identifiable living individual, the data subject. The personal data allows the person to be identified directly or indirectly by reference to an identifier such as a name or an identification number. Do note, however, that there is a sliding scale of relevance. For example, a reference to me attending a meeting or receiving an email is not my personal data unless I'm the focus of the meeting or the email. Next slide, please. So what are some examples of personal data? Well, it includes biographical information, so things like your address, your date of birth, national insurance number, phone numbers, email addresses, or passport number. It also includes someone's looks, appearance, and behavior, so the color of your eye, your weight, body shape, and character traits. Personal data also includes biometric data, so your fingerprints or facial images. Workplace information and information about your education, salary, the fact that you're a member of a trade union is also considered to be personal data, as well as information about how you perform in your role, including your appraisals, performance reviews, and disciplinary warnings. Private and subjective data is also included as personal data. So it's things like if you follow a religion or if you have political opinions, and also health information. So this is things like your medical history, information about your sick leave or occupational health appointments and reports. Next slide, please. Moving on to the right for employees to access that personal data. That's the focus of our webinar today, but there are, of course, other rights provided for by GDPR, such as the right to have personal data rectified or erased, or the right to restrict processing. The right of access, however, can be broken down into a right to confirmation from the employer that they are processing personal data, access to that data, and also specific information being provided about the data. We've listed out the required information on the slide, which you might be familiar with if you've ever drafted a response to an employee. For example, you need to tell them the purpose for which the data is being processed. Is it because it's necessary for the performance of the employee's employment contract, or is it so that you can comply with your legal and regulatory obligations? In the interests of time, I won't go through the entire list, but one thing to note is that the overriding principle is that data subjects should be able to access their data relatively easily without excessive delay or expense, which means that you have to make reasonable efforts to allow them access and not put unnecessary barriers in the way. Next slide, please. Article 15 goes on to provide further details on a processor's obligations. So it states that the controller shall provide a copy of the personal data undergoing processing. The initial request is free, but a reasonable fee can be charged based on the administrative costs for any additional copies that the employee requests. Where the request has been made electronically, and unless the employee requests otherwise, the copy data should also be provided in a commonly used electronic format, so you can respond in an email or a PDF document. It's whatever is the best way to get the information to the employee, provided that it's secure and that you can easily prove when it was sent, delivered, and opened. And lastly, an exemption applies where a data subject's rights to a copy adversely affects the rights and freedoms of others, for instance, their colleagues. Lucy will give a practical example of this later on in the webinar. Next slide, please. So what does the right to receive a copy of data entail? It's the right to access the data, but there is no standalone right to receive documents. A copy should allow the data subject to retain all of the information and to review it. As I said previously, any new request should be provided free of charge, and a reasonable fee can be charged for further copies. There's various options available for an employer providing a data subject with copies of their data, and a clear explanation should always be provided to the employee. For example, if the employer doesn't have a lot of results, you can probably provide an individual with copy documents redacted to take out information which doesn't relate to an individual's personal data. However, with larger searches, it might be better to summarize the personal data in a spreadsheet. Next slide, please. Whatever you decide is the best way to provide the data, timing is clearly an important factor when you respond to a DSAR. Article 2.3 sets out the obligation on the controller to respond to the DSAR without undue delay, and in any event within 1 month of receiving the request. That period can be extended by a further 2 months where necessary, taking into account the complexity and the number of requests. So looking at the 1 month deadline, 1 month is calculated by reference to the corresponding calendar date in the next month. So if you receive a request on the 13th of September in 1 month, the next 1 month deadline is the 13th of October, unless this falls on a weekend or a public holiday, in which case the deadline is the next working day. If there is no corresponding date in the next month, so if a DSAR is received on the 31st of January, the deadline is the last day of the following month, so it would be the 29th of February this year, unless that falls on a weekend or a bank holiday, in which case the deadline is the next working day. As I mentioned, there is a 2-month extension available when you're dealing with complex DSARs. However, there are a few things to note on this. Firstly, the extension should not be used as a matter of routine. A large volume of information does not necessarily mean that a DSAR is complex. It just means that there's a greater administrative burden on the employer, which you would be expected to deal with, especially if you're a large employer. What if you're dealing with a large number of requests? If you're dealing with an unusual increase in the number of DSAR requests, perhaps due to an increased publicity or a data breach, this could potentially justify an extension of time. Some other things that might justify an extension include if you're facing technical issues, for example, if you're dealing with personal data that's been electronically archived, or where you need to clarify confidentiality issues around the disclosure of sensitive information. Where there are large volumes of particularly sensitive information, an extension might also be justified if there's a lot of redactions that need to be made. Next slide, please. So that's a summary of your obligations as a data controller. Now, just thinking about the risks of if you get it wrong, the first thing to note is that it's an offence to delete data in response to receiving a DSAR. Your obligation is to deal with a request, not to find ways to avoid it. Of course, if you have deleted data as part of your normal data management processes, you're not expected to put in time to reconstitute it. There is also a reputational risk where an employer fails to respond to a DSAR. If the Information Commissioner's Office gets involved, it could issue an enforcement or a penalty notice, which most employers would wish to avoid, given the negative publicity that this would entail. Failing to respond to a DSAR can also support an inference of discrimination. For instance, the tribunal may question whether you're hiding something. Similarly, if you choose not to respond to a DSAR in the context of a discrimination claim, the claimant may argue that this is an act of victimization. Next slide, please. In the worst case scenario, an employee has 2 main routes of redress. Firstly, the employee can make a complaint to the Information Commissioner, and the Information Commissioner has the option to issue an enforcement notice or a penalty notice. This is illustrated in the case of First Choice in 2021. So it's where an employee was making a claim in the Employment Tribunal and submitted a DSAR to his employer, First Choice Selection Services Limited. The employer informed the employee that they would only release the information if they were instructed to do so by the Employment Tribunal. First Choice then refused to comply with the ICO's request to respond to the DSAR, misunderstanding that their obligations under the DSAR regime were separate to the ongoing litigation with the employee. In the end, the ICO issued First Choice with an enforcement notice requiring the employer to respond to the DSAR and to review its internal processes and systems for dealing with future DSARs. This is an example of the negative publicity that could come from misunderstanding your obligations under the DSAR regime. Where employers fail to comply with an enforcement notice issued by the ICO can issue a financial penalty of up to £17.5 million or 4% of annual global turnover, whichever is greater. Obviously, the highest fines are restricted to those significant breaches. However, it is worth being aware of the ICO's powers. The individual can also make an application to the court for a compliance order. The court can order for compliance depending on the circumstances and taking into account the proportionality principle and relevant factors such as the nature and the gravity of the breach, the reason for the DSAR, and the potential benefit to the data subject of receiving the personal data. Lucy will now look at tactical things that you can do to best manage any DSARs you receive, as well as how to deal with tricky requests in practice.
Thank you so much, Sajina, for a really helpful overview of the framework around DSARs. And as Sajina mentioned, I'm now going to turn to some more practical points around how you as the employer should respond to these requests, and also how you can be better prepared to respond to DSARs when they come in. So if we could go to the next slide, please. One of the first things to consider is whether you can treat the request as manifestly unfounded or excessive. And this is a standard which can allow you to refuse to respond to a request or to charge a fee for responding. And the first thing to say here is that this is a very high bar. So it's not the get out of jail free card we all wish it was. And even if the employee requests all of their personal data from the whole of their employment, that may not be enough to make the request manifestly unfounded or excessive. Declining wholesale is risky, and you need to provide reasons for declining to respond, as well as a reminder of the individual's right to complain to the ICO or enforce a response through the courts, as Sajina just mentioned. So the ICO has issued specific guidance on when a request might be regarded as manifestly unfounded or excessive, and we tend not to advise clients to apply this label unless it falls into one of these categories. So you receive the request, but the data subject specifically offers to withdraw it in exchange for some kind of benefit. So, for example, a settlement offer. Now, that might seem to apply to quite a lot of DSARs, which are made in the context of potential litigation and settlement discussions, but it would need to be that the data subject said, I will specifically withdraw my data subject access request in return for the settlement package that I'm asking for. And normally they're offering to kind of withdraw the DSAR and any kind of tribunal claims that they are making. So that probably wouldn't get to that level. You can also decide that a DSAR is manifestly unfounded or excessive if there's evidence that it's made maliciously, so with a view to harassing the employer or other employees, or kind of making the request for no other reason than to cause chaos. So that might be a situation where the data subject has suggested to other people that they intend to use the DSAR to disrupt the business, or if, for example, they're sending multiple requests on perhaps a weekly basis, such that it kind of becomes clear that the only purpose of them making the request is to create disruption. So it's not advisable to regard it as excessive on the grounds that there are no reasons given for the request, or perhaps because you regard the request as meaningless or a veiled attempt to put you under financial pressure to settle a claim, if improper or impolite language is used in the request, or you know that the data subject is intending to use it to fuel tribunal claims. None of those would really be enough to treat the request as unfounded or excessive. And it's important to note here that even if you do decide that a request is unfounded or excessive, it will still be risky potentially to refuse to reply to the request wholesale. What you might do instead is say, well, we think the request is manifestly unfounded and excessive as a whole, but we will decide to respond to this part of it, for example. So you might decide that actually you will respond to part of the request that relates to a dispute that you're having with the data subject, which you feel is more proportionate. You could also decide to charge a reasonable fee in the event that a DSAR is particularly large or wide-ranging. So when you do this, you need to be careful to justify the cost. This might be difficult for larger organisations who are expected to have more sizable resources to deal with these requests. So you need to think carefully about the level of cost that you're asking for, why you're asking for it. Unfortunately, you can't pass on the cost of things like legal fees needed for dealing with the request, but you might be able to pass on the cost of things like any specialist equipment that you need, or an hourly rate for staff time that is involved in dealing with the request. And if you're going to charge a fee, you need to let the employee know promptly, so why you're charging the fee and what it is that you're charging for. And then they need to confirm that they want to proceed on that basis. So the time for responding doesn't start running until they've confirmed that they want to proceed and they've paid the fee. So where it is appropriate to charge a fee, it can be a helpful delaying tactic. If we could go to the next slide, please. So Sajina touched on the Data Protection and Digital Information Bill, which is currently working its way through the House of Lords. It's at committee stage at the moment, so it might come into force later this year, or maybe later due to the election. It's pretty welcome news for employers and data controllers generally. I say that with caution, as we've only seen the draft legislation. We haven't seen any concrete guidance from the ICO. But the important thing is that rather than being able to refuse on the basis that a request is manifestly unfounded or excessive, employers may now be able to refuse responding to DSARs which are vexatious or excessive. So that seems to be a lower bar than what we currently have. And that's a lower bar for being able to refuse a request or part of a request, or charging a fee for responding. And it's looking from the current draft legislation like that vexatious label could apply to requests which are not made in good faith, or which are kind of otherwise an abusive process. And now it's not clear exactly what that means, but it could be the case that requests that are made kind of with a mixed motive, so those which are used to get early disclosure in tribunal claims, could fall into this bucket, but we don't know until we get the guidance from the ICO on exactly what that means, so something to look out for when it comes into force. It's also worth noting that under the new legislation, if a request is vexatious or excessive, then as with the manifestly unfounded or excessive request currently, you're able to charge a fee rather than to refuse. And it may be the case that the ICO looks more favourably on you if you consider it charging a fee for responding to a request rather than refusing altogether. So it may not completely get employers off the hook, but we might see a trend similar to that which we saw with tribunal fees, where we saw some of the kind of more try-on type claims drop off. We might see the same trend with requests which are kind of a pure phishing expedition or only designed to put pressure on employers. If we could go to the next slide, please. So another tactic that we get our employer clients to consider upfront is attempting to narrow the scope of the request and potentially extending the period of time to respond. So you need to do this as soon as possible where you receive a request which is wide-ranging. You can't force the data subject to clarify the scope of their request, but it can be a helpful tool in that it both stops the clock running for responding to the request and potentially narrows the scope of what you need to respond on. So the time frame for responding is paused while you wait for clarification from the data subject. And you can ask things like what information the data subject is specifically seeking, what processing activities the request relates to. And the latter question could be quite interesting, I think, under the new DPDI bill that I mentioned earlier. So if you ask the individual what processing activities they're interested in and they've got absolutely no idea, that might indicate that they are making the request in bad faith, so that they're not actually interested in how their data is being processed, and they're using the DSAR as a tool to get early disclosure in a tribunal claim. So you should only use the clarification tactic where necessary. So if the employee's already made a focused request, it's probably not a good idea to ask for clarification. It could seem like you're doing that purely as a delaying tactic. Just to give you a quick example of how the time limit's paused until the clarification's received. So if, for example, you get the request on the 14th of May, then the default position is that the response is due on the 14th of June. But if you then make a clarification request on the following day, so on the 15th of May, and get the response from the data subject on the 18th of May, the clock will be stopped for 3 days so that the response date becomes 17th of June. So that buys you a little bit more time, and possibly more time if you decide to apply the 60-day extension that Sajina mentioned. Can you disregard the request if you don't get any response on clarification from the employee? The answer to that is no, you shouldn't do this. You should wait a reasonable length of time for them to respond. The ICO guidance suggests that this could be a few weeks or a month, and then you should proceed on the basis of the information that you have. So there are different ways in which you can seek clarification. So as I mentioned, you could ask the employee what subject matter they're looking for data in relation to, what timeframes they want you to search within. I was dealing with a DSAR once where the data subject requested all of her data from the whole of her employment, so a kind of real kitchen sink request. We provided her with an inventory of all of the categories of data that could be caught within the request, which included very boring things like diary invites and routine management emails. And it actually prompted her to withdraw the request because she couldn't bear the thought of going through it all. So that was a big win there. Not always guaranteed to happen, but worth exploring. Next slide, please. So there are various exemptions which might apply to the right of access to personal data. And I'm just going to run through these on the slide. So personal data where a claim of legal professional privilege could be maintained in legal proceedings. So a classic example of that is any emails containing legal advice regarding the data subject. Those would be excluded from the scope of the DSAR. Any personal data which is processed for the purposes of management forecasting or management planning, where disclosing the information would prejudice that management process. So a classic example is if there's a staff redundancy programme which is planned, and information about it could be disclosed to the data subject as part of the subject access request. If that would prejudice the outcome of that redundancy programme, then that's an example of the kind of data that could be withheld from scope. Any confidential references given for employment training or educational purposes. So we don't actually see this come up very much in practice, and that's probably because most of the references that are given aren't necessarily confidential. So the individual will have some idea of what information is going to be given about them to the next employer, whether that's because the employer has a kind of policy of only giving dates and job title information, or whether they're already privy to the type of information that might be reported in, for example, a regulatory reference. But that is an exemption that exists. Personal data about intentions in relation to negotiations between the employer and the data subject. So if there's kind of information about settlement negotiations that the employer might be having with the data subject, then that would be excluded from the scope of the DSAR. And also any personal data which belongs to other data subjects. I'll come back to that one when we look more closely at tricky scenarios. It's important to note with all of these exemptions that if you decide to exclude data from scope on the basis that one or more of these exemptions applies, it's really important to keep a record of why you're doing that, so that if you're ever challenged on why, for example, you've redacted something or kept it out of the scope of the response, you're easily able to justify what you've done. So if we could go to the next slide, please. Here we've got the first example of a tricky request. So this is a classic, what we call kind of kitchen sink request. This request has an unlimited date range and very broad search terms, and an initial search has produced over 200,000 documents for the employer to search. So, as I just mentioned, one of the best things you can do with this kind of request is to ask for clarification. So the subject matter of the data that's requested. So does the data requested relate to a particular event, decision, or process? And what are the timeframes within which the data subject would like you to search? You might also want to consider with this type of request whether you apply the 60-day extension. And if you do so, then you need to notify, as Sajina mentioned, the data subject before the first month has passed after the data subject is received. And as Sajina, I think, also mentioned, just having a very kind of wide-ranging request may not be enough to justify saying that it's complex and applying the extension. You'll also need to think about whether, for example, you need to redact a lot of information in order to respond, or whether there's kind of particularly sensitive information that you're looking at, and explain to the data subject why it is that you think it's particularly complex such that the extension is justified. You can consider targeted filters and searches, so and also whether there are any kind of categories of information that you can exclude, so things like large group emails or internal HR circulars. That's unlikely to amount to personal data, and make sure you just understand what personal data is likely to emerge. Decide on the format of your response, so whether you present it in a summary table or documents. And if you think about all of these questions at an early stage, that's likely to make responding more efficient, because you can sort of determine a protocol and strategy up front and then simply apply it without needing to kind of go back and think about what you've done and whether you can justify it. And if we could go to the next slide, please. We've got the second of our tricky request scenarios. So this is a really interesting one, and one which comes up quite a lot. So we've got a request from an employee who's accused of sexual harassment, and the personal data that they seek would identify the accuser and the investigation witnesses. So the starting point with this one is that there's no obligation to disclose the information if it would also reveal information relating to another individual who can be identified, unless steps are taken to obtain their consent and they obtain their consent, or it's reasonable to disclose without consent. If we could go to the next slide, please. So best practice would probably be to, as a first step, seek consent from the people involved first. And then in the event that they're not happy to give consent, you'll need to perform a bit of a balancing exercise between protecting the privacy of the individuals who've perhaps given evidence in this investigation or made the complaint, and the interests of the data subject who's requesting the information. And in performing that balancing exercise, there are a number of things to consider. So would not disclosing the data prejudice the rights of the person receiving it? And in considering that, you probably need to take into account that they might also be receiving it, or some of it, as part of a disciplinary process, if there's a disciplinary process in relation to the harassment. And so would them receiving this extra information, the benefit of them receiving this extra information, outweigh the risk to the individual who could be identified, especially if there's a risk of perhaps retaliation against that individual? And you'd also need to think about, have those individuals been given any assurances of confidentiality confidentiality, and would those assurances be breached if we did just decide to disclose this data? As part of this, you should also think about whether there's any kind of special category personal data of an individual that might be disclosed. So any information about their health, for example, that might tip the balance so that you're not in favour of disclosing the information to the data subject. Whatever happens, you must keep a record of your kind of workings out, your thought process and decision, because it's one of those cases where there's simply kind of no right or wrong answer, but it's very important to kind of justify your thinking. If we could then move to the next slide, please, to consider the third tricky request. So this is a request which involves personal data that's likely to be on employees' personal devices. So, for example, WhatsApp messages between colleagues. So the starting point here is that the employer is only obliged to search for personal data that it actually processes. So if employees are interacting on personal devices on a purely social basis, then it's unlikely that the employer would be deemed to be kind of processing that that personal data, and would probably be kind of outside of the scope of that DSAR. But if, on the other hand, the employer permits the use of personal devices for work purposes, so for example, for online collaboration or staff management, then it's more likely to be in the scope of a DSAR. And relevant factors to consider would include whether there's any kind of formal policy around the use of personal devices, and do people regularly operate outside of that formal policy, and to what extent. The nature of the personal data likely to be on those devices. So is it likely to be the personal data that the data subject is seeking, and the scope of the DSAR and the context. So if, for example, the data subject is kind of looking for information about a redundancy, is that going to be the kind of thing that's being discussed on personal devices? So again, there's no easy answer to this, and these are all factors that you would need to consider and document your thought process around that. If we could move to the next slide, please. So how can employers address the issue of personal data on employee devices? So it's best if you can avoid this issue entirely, and the way of doing that is just to set very clear boundaries and manage employee behaviour around this up front. For various reasons, it's not a good idea to allow communications on personal devices relating to work, because those messages could be discoverable in future litigation, or they could be scrutinised by regulators such as the FCA in the financial services space. So important to be very clear about expectations. If employees are expected to only use employer-owned devices to conduct work-related business, it's important to be very clear about that. And the best way to communicate those expectations is by publishing an internal policy, so kind of bring your own device to work policy, which should cover acceptable use levels, the importance of information security, and the expectations that you have around privacy and the extent of an employer's right to access, and then just make sure that the policy is properly enforced and publicised and stuck to. And then you can also cover expectations in a data protection policy and privacy notice, so that reflects any limitations on employees' expectations of privacy, assist employers to meet the requirements of future DSARs, and also adhere to any regulatory or commercial obligations relating to their data security. And it also obviously minimises the risk of future disputes with employees, as well as kind of employee relations risk, if you minimise the communications on work devices. So that avoidance approach might not work for all employers, because there might be a kind of well-established culture of using personal devices to discuss work-related subject matter. So that where such a culture exists, it can be quite difficult for an employer to reverse that. And if it's common practice, then I think an employer would certainly struggle to argue that there was no good reason to believe that employees were processing personal data. How you approach that, if you decide that you do need to search devices, if a search is necessary, then we would suggest that you consider using a third-party IT expert to conduct the searches, because if you do that, there's less risk of people kind of inadvertently deleting relevant material, and also ensuring that there's a kind of consistent approach taken to capturing the personal data that might be held on their personal devices. Another option would be asking employees to carry out their own reasonable searches, but you need to give very clear instructions on what's needed to make sure that everyone understands the nature of their obligations and what they're looking for, and how to record results properly. And it would be advisable to remind people not to delete relevant information when you're doing this as well. If we could move to the next slide, please. So, having touched upon how you should deal with DSARs when they arrive, we thought it would be helpful to run through some suggestions for how you can be better prepared for DSARs when they do come across your desk. Giving some thought about how you can be DSAR ready. And this is something we're talking to our clients about a lot, because we've seen a real uptick in DSARs being used. And we quite often see that clients are kind of struggling to keep to the statutory timeframes. Next slide, please. So one of the steps that you can take is ensuring that your data privacy notices and policies are sufficiently detailed and fit for purpose and kept up to date. Because when you respond to a DSAR, you'll usually need to provide your privacy notice and kind of confirm that the data is processed in line with that. So that's important that it's refreshed on a regular basis and kept fit for purpose. You might want to consider introducing a DSAR portal or a specific link for requests to be submitted. So this can be helpful in terms of certainty that something really is a DSAR. As Sajina mentioned earlier on, it's not always completely straightforward, that question. And for similar reasons, you could consider nominating a key internal person with overall responsibility for making sure that DSARs are responded to consistently and appropriately. You could also put in place an internal DSAR checklist or protocol or response system, so a kind of aid memoir internally of how to deal with DSARs. And this is quite important, as it will help you kind of leap into action once you receive a DSAR and respond in a timely manner, rather than kind of spending time and taking advice on how you'll approach it. But you can also train staff to become familiar with it, and just to be able to use it when they receive a DSAR, and it will obviously help ensure consistency across the DSARs that you respond to. And there's a couple of kind of training and policy pieces to consider. So an investment that you can make now, which will reduce risk for future DSARs, is taking the time to train staff on appropriate use of firm systems and personal devices where that's appropriate. So helping them to understand the kinds of comments that they make on, for example, instant messaging software such as Teams, that can obviously crop up in DSAR results, but also increase litigation risk. And putting policies and guidelines around that. And to that point, also training staff on the internal process and on responding to and recognising DSARs. So that's kind of invaluable training for your HR team. Next slide, please. So communication with the data subject is very important, and that's something that's often forgotten by employers. So it's important to get the tone of communications right and to know when to communicate about things like appropriate timeframes. So it's worth getting a suite of communication templates in place up front so that you can respond quickly and efficiently, and your internal checklist that I mentioned can give you prompts as to when you might need to send the various communications. So that covers all of the steps that you can take to be more DSAR ready. The remaining steps on that slide are less about pre-DSAR readiness and more about sensible first steps you can take early doors in order to respond quickly. So things like carrying out an initial assessment, working out how many docs are in scope, whether you need to apply an extension, and therefore what the deadline for replying is, and also whether the request requires clarification, which can feed into your timeframes. You should also consider whether any exemptions might apply, and as I mentioned, document your decision making in that regard. Next slide, please. So having run through all of that, just to sort of flag the areas where Fox Williams can support you with DSARs, both with your DSAR readiness, so how prepared you are once you receive a DSAR, and also once a DSAR is received. So we can assist with setting up an internal DSARs response protocol. We can help you with a tailored suite of DSAR communication documents for each stage of the process, and also assist with training staff on appropriate communications, including also how to recognise DSARs and the steps involved in responding, and also assist with appropriate policy documents, so things like guidance on the appropriate use of systems, and also with refreshing privacy notices. And then once the DSAR is received, we've got considerable expertise in assisting with complex and data-heavy DSARs, including things like data searching, and have done so with DSARs involving kind of around 200,000 documents, filtering data and reviewing it for relevance and helping you get that into an appropriate format for responding. We've also, in the past, used paralegals to make sure that we can help respond to DSARs in a cost-efficient way, and have used also third-party data management platforms, often with AI tools embedded, to help respond to requests efficiently. So that brings us to the end of our presentation, and we wanted to leave some time at the end for questions. Thanks very much.
Thank you to Lucy and Sajina for some really helpful guidance there on something that we're all, if we haven't encountered it already, and I'm sure most of you have, we will inevitably be encountering in our day-to-day practice in the future. So we've got a couple of questions for Lucy and Sajina. The first one is, when looking at Slack messaging, for example, do you simply search the employee's name? For example, if you know someone is being spoken about, but their name isn't referenced, so it's not something that's shown up on the search, would that information need to be included when you respond to the data subject access request?
So in terms of searching, I think what I always recommend is not simply searching for a data subject's name, but also using appropriate search terms so that you can sort of search for their name and the kind of subject matter that they are looking for, so that you're responding to the request in a targeted way, and you're not just dredging up all and any personal data that might be on Slack, because then you might end up giving the individual more than they're actually asking for. In terms of something in terms of conversations about that individual which don't necessarily identify them, there's then a question about whether that amounts to personal data at all, if they can't necessarily be identified from the conversation. You would probably need to look at the conversations in the round and work out whether whether if you look at all of the conversations, you can actually identify who's being talked about. So it probably need to be considered quite carefully, and on a kind of case-by-case basis.
I think that's right. And where often we see complaints being made is when there's a claim after, so there's been a data subject access request, and some of the materials that come out in the disclosure, which covers a sort of wider range of information, includes data which somebody will say, well, hang on a minute, you knew about that at the time I did my DSAR, why didn't you provide it? I think that if you've got so if the employee gives you search terms that they want you to use, and you use those, and this information doesn't come up, then that's your perfect excuse for why it didn't come up, because you applied the search terms, and clearly if the name wasn't referenced, it wouldn't have come up. But as Lucy said, you've got to be, if you don't get search terms and you're kind of plugging in search terms, you need to be a bit careful about not being too restrictive on that. But I think that even if you apply the search terms, but you know that this is information about the individual, and it is possible to identify who they are, perhaps through another email in a chain, for example, then even if it's not come up using the strict search terms, but you know about it, I think you have to think very carefully about the fact that it probably does need to be disclosed. And I think this is a really good question, because a lot of messaging systems it are very informal, and sometimes you use things like initials or nicknames for people that might not come up. But I think that that's a view that would have to be taken when you look at the materials that have come up in your searches. So another question is, can we find an extensive list of what would be considered as data to include in a DSAR request? So, for example, private notes saved on an HR platform, which is used for performance management. Lucy, I don't know if you have any thoughts about that.
So I think that if you can identify the individual who's being talked about within these private notes on the platform, then it probably would be within the scope of a request. In terms of the extensive list, that's something that we can help with. Also, the ICO has quite comprehensive guidance on what could be considered to be personal data. But I think it's a good idea, and this is kind of part of the whole DSAR readiness piece that we were discussing. It's probably a good idea for you as an organisation to have a really good think about all of the places within your organisation that you're storing personal data, and that will help give you a bit of a roadmap when you're responding to a DSAR of all the places that you should be looking.
Thanks, Lucy. So a question about handling managers deleting emails. No matter how good your policies are, it sometimes happens when someone feels a little anxious and embarrassed, perhaps, about what they've put into an email or another form of message. Can this information be recovered, and should it legally be recovered if you know that information has been deleted?
So I think often it is possible to recover this type of information, because often we find that employers will have backup systems or archive systems which can be searched in order to find data which has been deleted. Whether or not it's reasonable to do that would sort of depend on all of the circumstances of the case. And I think in this case, sort of what had been deleted and why it had been deleted. If you felt that, having made kind of inquiries, there was a good chance that there was something within the scope of the request that had been deleted, it probably would be reasonable to search backup systems, and certainly that's always something that you should think about when you get a DSAR. Do you need to kind of search all systems just in case there might be something that has been deleted? Maybe that's going a bit far, but I think if you know that there's a kind of a pattern of people deleting emails, and you've kind of worked out that there could be something that's been deleted that's within the scope of a request, then that's probably a case where you would need to make further inquiries.
I think also it may highlight a sort of matter that needs to be dealt with under a disciplinary process potentially, because if you do have policies and requirements about this, and for those of you working in regulated businesses in particular, the deletion of information can be very problematic, as can the fact that it looks like somebody is hiding material to sort of cover tracks potentially, and that's incredibly serious. For example, if you're a solicitor and you have done something wrong and you're trying to cover up, that's actually probably worse than the fact that you've done something wrong in the first place, because it goes to your integrity. So if people have been deleting them, don't just think about, well, what does this mean for my obligations under the DSAR regime? There may be some wider issues that you need to deal with in terms of people kind of doing this stuff.
Yeah.
So, sorry, Lucy, yeah, did you?
Yeah, I was just going to say it's probably worth also flagging that where, as is so often the case, you have litigation that's ongoing alongside the DSAR, it's important to send what we call a litigation hold to any custodians who might have documents relevant to the issues which have been raised in the litigation, just reminding them their obligations not to delete anything. And quite often we do see, as we mentioned earlier in the presentation, a DSAR arriving just as kind of the first letter before claim, or kind of first letter setting out concerns that might lead to litigation is received. So that's a good juncture at which to kind of let people know that they really shouldn't be deleting anything.
Yeah. So another question about an increase that's been experienced in requests where individuals confirm they want to search for initials. How reasonable is this? So an email search for initials could find a higher level of results to sort through, which are clearly not relevant, because obviously if you've got certain initials that appear quite commonly in common words, you might find that. Another example that I've had before, certain names are very common. So if you've got 20 Marks or Daves in the organization, you might find a lot of hits. Lucy, any thoughts on how we deal with that?
So I think there it's really important to design your search terms appropriately. If you've got any kind of guidance on the subject matter of the information that is being sought, or the kind of timeframes within which you should be searching, then you can use those to target your search terms, so that to the extent you are searching for initials, you're only doing so against information which is otherwise going to be relevant. So I think that is a reasonable approach to take, for example.
Yeah, thank you. So questions keep rolling in. I'm just conscious of the time. So another question from someone who's had instances where employees also expect for HR to share their written notes from a catch-up meeting. Those are not sort of formal meeting minutes as such, but key points or the gist of what the employee has raised during the meeting. Would those notes typically be disclosable?
Yes, so it depends on a number of things. So if they're handwritten notes, a question arises as to whether they're kept in a sort of so-called relevant filing system, and that sort of depends on if they're in a notebook, kind of what's that notebook for? Is it kind of a notebook of any day-to-day matters that could arise, or is it kind of particularly related to that data subject? And so in that instance, it will depend on kind of where those notes are located and what the kind of structure of that particular kind of notebook is. If it's just a sort of Word document with kind of bullet point notes, not kind of formal notes, but clearly relating to the data subject, and kind of stored on the HR system, then I think, yes, that would be disclosable.
Goes back to that quick thing I mentioned at the beginning, which was the hot topic when I first started dealing with DSARs, where people were quite tempted to throw their notes in a pile in the corner of the office, and they wouldn't be a relevant filing system and therefore didn't need to be searched. I think though that sort of raises a kind of wider issue, perhaps from an employee relations perspective, is that it can be really good practice, obviously, to have notes of meetings, whether they don't have to be verbatim. And so one thing that you might typically do is follow up with an email to somebody about what the meeting has been about and the key points, and that would obviously be disclosable. But kind of keeping minutes and creating a helpful paper trail is very helpful. So I guess don't be entirely tempted to throw your notes into the corner of the room, because you can manage the paper trail in a helpful way through doing that. So I think time perhaps for one last question. An employee who resigned made a DSAR request requesting payroll information. We prefer not to send it via email, things like payslips and P60s, but rather give access to it through an e-pay system to the employee using a private email address. Can this be done, or are we obliged to provide it as PDFs?
So there's no specific requirement to provide data in PDF format. So I think you could do this. I suppose the question would then become, would they actually be able to access it, and would they be able to access information about how their data was processed? So you might need to consider giving that information in a kind of separate communication.
We are bang on 10 o'clock. Thank you everybody for listening and for your really interesting questions. I hope that you now feel better prepared for the inevitable next request, which will land in your inboxes probably over the next few months. So, but obviously, if you do have any further questions or you need help on any of this, then please do contact your normal Fox Williams contact. We'll leave it there. Thanks very much and look forward to seeing you at the next webinar.